2023. Yes.
Solution, if you see the said witness statement, will you be able to recognize it?
Yes, I would.
Can you see the statement?
I can
It's appearing
recognize.
on your screen right now. Can you see the statement?
Can you show me, please? Because okay. Yes, I can see it. Yes, that is my statement.
Don't go too far. That's not your schedule. Yes.
Yes.
We have identified it.
Is that your statement, Mr. Lucian?
Yes, that is my statement.
What would you like the court to do with this statement?
I want the court to adopt my statement as my evidence in this matter.
I have an issue with this. I don't have the dates you refer to, as well as the opponent's signature. Local public signature. I can't see that. I also don't find any dates.
Is it part of the documents that were served on you?
Yes.
You have a copy? So, Clemens counsel, the defense counsel is saying he has two issues. He is unable to see the date on which the document was sworn to, and at the same time, he has not found the signature of the witness thereon.
If you can I say something? Can I say something?
You can speak, Mr. Lucian.
Yes, about the statement. Is as per the law here in the Romania. I sign in front of the notary, and the notary is legally see my signature, and you can see at the end of the paper, everything is translated, and the notary is stated there in English that I sign in front of him, and also you can see there the date of the document. So I don't see where is the problem.
Counsel, yours is an observation. It's not an objection, isn't it? You said you want to make observations, which I have recorded as such. You made the observation that you have not seen the date, neither did you see the signature of the deponent. That's what you said.
The sense of showing we as the penance counsel is to raise questions to the center of the document. And in this case, we have observed one, there is no signature of the opponent on this document. Even if he claims that he signed for emotion, at least that should be the fashion of the sign. before it is translated.
So is it now a proper objection you are raising? Because the document is not to be tendered. That document is not to be tendered. It is a document that contains the evidence in chief of the witness, which he has now identified. As he has identified, he has made an application that he wants the court to adopt, which in the normal way, he is the one to adopt, not the court to adopt.
Stop this.
He is, as a witness, it is his statement. The court cannot adopt that. He is the one to adopt. After adoption, then subsequently the court will now rule, taking it as the evidence in chief of the witness. As it is now, it is not been tendered in evidence.
But as long as it's going to rely on it,
Yes.
as evidence,
Yes.
it is being tendered in evidence. I'm allowed an affidavit that does not show the opponent's signature on it. It's an issue.
That is why. Look, is it the right time for you to bring up this matter? Is it the right time for you at this stage when the witness says, this is what I deposed to before a notary public in Romania, and I have recognized it, and he wants to rely on it? That's why he says.
And he has also explained the reason why there's this, because there's a law there in Romania. So what you do is you sign on the document.
I will go to that.
Stop this.
So I think you can, this one, if you have any issue with that, it should not be at this stage. Because at this point, the witness is not tendering it as an evidence. No matter what, no matter wherever he obtained the document, no matter how, wherever it is being obtained, he can bring it to the court. If he brings it to the court, it is now left to the attorneys now to X-ray, to look at it in the course of the proceedings, or at the end of the proceedings, or during, address or whatever. But I don't know, I'm not telling you, I'm not changing your style. You have your own style of doing it, but it should be within the purview of the law.
But I hear my when we're proceeding from it, I was cases that before adopt or grant the wish of a witness to adopt the basic requirements, which is as to showing that he actually signed and then
Okay, do you know what I will do? It's simple. You have raised your observations. The witness has explained, so I have to take the explanation of the witness, and then I listen to the counsel. If it's purely an objection or observation, I will now tell the position. I will set the position of the court. Yes. Let me hear from the counsel, Clemens counsel.
Can I say something more?
The witness would like to explain the reason for the
Yes.
signature.
If you go,
Witness, you have a counsel before the court. You have a counsel. Let me take the witness, the counsel first, in response to what the defendant's counsel said. Yes, counsel.
Yes, my lord.
yes, I just want to say that is very clearly mentioned in the page 6 and 7, where the notary said authenticated my signature, and is stated there as per the public law here in my country. It's authenticated this document. So and also you can see the date. The date is 14.
Allow you to make your submission.
Mr. Lucian, please hold on.
Yes.
The date, as you said, the date.
The date of the document
is on the page 6.
Is on page 5.
Yes, 6.
Document, my lord.
Is it page 5?
Yes, my lord. Page 5. The document is written is back and front.
Back and front.
Yes, my lord. Back and front, my lord. So it's on page 5
Page 5.
of the document. My lord, you will see the signature authentication.
There is also a signature
Authentication.
signature of authentication.
Signature authentication. As duly stamped by the notary office in Romania.
Duly stamped at the office of the
Notary public in Romania, my lord.
yes.
And the date is clearly stated there, my lord, as the 14th day of November 2023, my lord.
2023.
Yes, my lord.
Okay.
Can I explain more about this document? Yes, you can see that on the page 6 and 7, the notary said clearly that I sign in front of him. So as per the Romanian law, we sign in front of the notary and he is authenticated our signature. And this is to protect our signature and to protect these documents to be copied or fake by somebody else who knows my signature. This is the reason behind. So all the documents in Romania we sign in front of the notary, and notary is protecting this document by his stamp and the signature.
Attention to respect of notation we use. One is
One is
sorry, order 41 with 12 of this honorable court rules that makes mandatory the proof of a court or a notary public seal is outside the court, which is not this is the respect of this affidavit relied on by the courts. Then the second one is also section 117 evidence, subsection 4, which deals clearly stated that the person must sign. And in the absence of this signature, whether from the person he claims supposed to before his very book. If you now, I'll give you outside the portfolio of law. Then this issue of two is also very powerful.
I have listened to the defendant's counsel in his observation raised regarding the document which is the witness statement on oath, whereby stating that he is unable to find the date and signature of the deponent, that is CW1, on the witness statement on oath. To this, counsel for the claimant contended that the date of the document is at page 5 of the witness statement on oath / the document. And also that the document is authenticated and duly stamped at the office of the Notary Public in Romania. Counsel maintained that the date is clearly stated as 14th November 2023. I have carefully read through the witness statement on all document. I have carefully read through the witness statement on oath, being a document that is drawn and sworn to before a notary public in Romania, which is mostly guarded by the laws and practice in the said country. I have read the statement and the affirmation made by the witness on page 6 and 7 of the document, as well as have seen the signature and stamp and name, the signature, stamp, and name of the notary public in the document. It is at this stage that since the witness has identified the document and placed reliance on it, it is my view that this court has no difficulty in taking the document as the evidence of the witness in chief of CW1. Further to this, counsel for the defendant is at liberty to address this honorable court at the address stage in these proceedings as to whether or not this court can give credence to the document in view of this honorable court. This court is one whereby its practice and procedure may depart from the application of the Evidence Act in the interest of justice. Hence, the issue of provisions guiding and guarding the swearing to an affidavit is provided for under the Evidence Act, laws of the Federation 2011 as amended in 2023. In the circumstance, this court takes the document as the evidence in chief of CW1.
Hello. Witness, are you with us?
Yes, I'm here.
Okay. In your, okay, hello. You seek to, hello, the witness has adopted his witness statement and oath for this honorable court.
Yes.
You seek to tender his hand.
Yes, counsel.
So, the witness has adopted the statement of oath. My lord, witness, are you with us?
Yes, I'm here.
Now, in paragraphs 4,
Yes, hello.
5,
Is the sound, the voice, it's here with echo. If you use another microphone, I understand.
okay,
better.
just listen to me so you can.
Okay, okay.
Just be patient.
Yes.
In paragraphs 4, 5, 19,
Yes.
and 20,
Yeah.
and
Yes.
23 of your witness statement on oath, you made
4,
mention
5, 19.
4, 5, 19, 20,
Yes.
and 22, my lord, and 22.
Yes. Okay. That is.
You made
Yes.
mention of certain documents. You see these documents, will you be able to identify them?
Yes.
Identify them one after the other.
Yes, I would.
Did you file a list of documents?
Yes, my lord.
I've not seen it yet. That's why.
No, does not have a list of documents.
That's
That's
what-
not completed.
There was an initial, the documents are the same as the documents that were completed at the initial stage. No change, my lord. No change to the documents. Only one of the documents are excluded, which is the power of attorney. Meaning as the witness is now representing.
Since when? What is the date? What is the date? Oh,
My lord, the initial statement of was dated in 2016. my lord.
after the initial statement of fact.
Yes, that's after the initial, all subsequent amendments.
It's,
Here, the same document. No
accompanying
difference.
the initial statement of fact is the witness statement on oath of one F.R.A. Williams.
Yes, my lord.
Is it?
She is no longer the witness of the
Yes.
claimant.
Which one are you referring to court to?
The claimant is now representing himself.
Which one are you referring this court to? As the list of the documents?
The list of documents was filed with
The
the
counsel for the defender as well is saying he has not laid his hand on it.
list of documents is contained in the amended statement dated 15th January 2024, my lord.
You know, there are several amendments here. Claimant reply to. Dated when?
15th
Put it out, bring it out.
15th day of January 2024, my lord. Is titled Amended List of Documents.
That list of documents.
Amended List of Documents, my lord.
They are yes. They are 9 in number.
Yes, my lord. There are some that will be omitted, like the number 1 and number 3, my lord, on the list. Number 1 and number 5.
You will skip number 1 and number 5.
Yes, my lord. We'll go with the rest.
Yes.
Sorry. These are the documents.
So in essence, there are 7 now.
Yes, my lord, just 7. my lord.
Did you see it, counsel for the defendant?
There are no documents for the we had five reference.
You don't have.
They don't have a defense. Not file so by that token, by the law, that an amendment dates back to the date of matter. This is not the law for the I don't give you a reference to a document that
You see, you will still take me to my former position. These are matters that really they are germane. This matter is germane with the earlier one I have just ruled on. I cannot be here to conduct a case for a counsel. What is relevant or important here is he has made reference to this. I asked him, did you file list of documents? He said yes. Now, you are now raising an issue that the documents are not front-loaded. And that you stand now. If the documents are not front-loaded, he has listed them here. You still have an opportunity to deal with the situation at an appropriate time.
He has applied to that.
Yes, which are contained, the list is here. He has provided the list of the documents. Yes. What's your problem with it? You see, my little problem with you that when you are raising something, you don't do it formally. As if you are making an observation and you stop at that. If you are raising an objection, you do it properly. Let there be, yes, my lord, I'm objecting to so stand. My reasons are this and that. I will now take it. He will reply. Then I give my ruling on that. Then we make progress. First and foremost, did you make an application to tender them?
No, my lord, I haven't made an application to tender.
Okay.
I only asked for the documents to be shown to the witness.
Okay. He said he hasn't made any application. He has asked for the witness to identify them. Yes, show to the witness these documents. There are 7, I believe.
Hello.
Yes, hello.
There are some documents here that you
Okay, can
Yes, solution.
you show
There are
me
some
the
documents. Please,
documents?
can you identify the documents one after the other?
Yes, please show me.
Yes.
Okay. Yes. These are the documents. This first is my curriculum vitae, it's my CV, and the passport.
Taking the one after the other. Let's keep going on. Let's go.
Yes, this is my passport.
Go to the next, identify that one.
This is the letter of employment given to me by the defendant. It is dated 3rd January 2013.
Go to the next.
Okay, can you put on the camera, please? Okay, and this is the third is the email dated 12 June 2014. And the email dated 1st July 2014. It's emails. Yes. Also, this one is email. Also, this is what I give to the court. Okay, this is can you bring more close, please, to the camera? Yes, this is another email, which is dated on 7 July 2014, if I'm correct. Is also email which I write myself. Yes. Yes, this is the solicitor's letter dated 17 December 2015. Correct?
Which one did he mention last now?
The solicitor's letter.
December
2014?
2015.
That is later from the solicitors.
Yes, my lord.
That's number 6.
Number 6, yes, my lord.
It
What document is appearing twice? 6
dated what
documents.
date?
December
17th December 2015. And then which one again?
That is the last one.
Next. Okay. It said my CV passport, my international passport, my CV, letter of employment dated 3rd January 2013, email dated 12th June 2014, email dated 7th July 2014, and letter from my solicitor dated 17th December 2015. And which one again?
We also have a certificate in compliance with section 8.
That's the 7th one.
Which we tend to. Familiar with the document.
Okay, yes, identified them.
Yes.
What next? Are you applying to that with evidence?
Yes, Lord, I'm applying to that document.
Defense counsel, there is an application before this court to tender these documents in evidence. What's your position? Yes. You are objecting to the tendering of the documents in evidence on the basis. How many is it a base or basis? Basis. On the basis of one.
Is that the amended processes will not upload these documents as required by rules of process.
Does not contain the front loading of these documents as required by the rules of this court. Which rule?
In particular,
The order 2, rule 10 and 11. Yes. Secondly, with regards to the second document, second document, which is the international passport of TW1, yes.
Well, what is now what we have here is a photocopy.
We have only a photocopy of the
It's not certified.
which is not certified
As a public document. Why?
as a public in line with that section. Yes. Yes.
I have a word to say here. Sorry.
I think at this point, I will ask the council service clients to keep quiet, but
The court will do that, and the council, in as much as you are representing him, if he wants to speak,
yes,
he has to take the permission of this honorable court while doing that. He should not be interjecting. Tell him not to interject. Witness, don't interject. You have a counsel already in court.
Sorry. Sorry, my lord. Sorry.
Yes. We cannot be taking submissions from our counsel or taking position from our counsel and at the same time recording what you are saying as well. Yes.
Document 3 is the table copy. And no foundation should be
It's a photocopy and no foundation. It's laid. Yes. Why the rest of the documents are you opposing? Are you opposing for the rest of the document? You have
first ground covers the entire document.
yes.
Then I will identify
Number 2 and number 3.
Yes, number 2 and number 3. Number 4. Whether emails,
Layman's counsel, what's your think about the grounds of its objection? Show him, give him the documents.
With respect to grounds 1 of their objection, my lord, all these documents referred to, which were received to tender at this present time, were folded with the initial originating processes.
They are front loaded
with the initial originating processes, my lord.
with the initial
Originating processes, my lord. Which have been served. Apologies, my lord. It's dated as far back as 2016, my lord. As far back as 27th of January 2016, my lord.
7th January 2016.
Yes, my lord.
And filed?
Filed on the same day, my lord. Yes.
Yeah.
Apologies, my lord. 27th of January, filed on the same day, my lord, 2016.
Yeah.
And was duly served on the defendants. My lord, the essence of my lord. The counts
It's for
defendant, my lord, to be made aware of the case against him.
to
To be made aware of the case against him.
remain.
Made aware of the case against him. Well, the claimant's case has not changed from the originating processes filed in 2016. All documents remain the same as those that were filed in 2016. And my lord, in our amended processes dated 15th January 2024,
In our
amended processes dated 2024, 15th January 2024, which is most important, my lord. An amended statement, list of documents as required by the law or by the rules of this honorable court was duly filed and served on counsel for the defendant, my lord. My lord, as to the second objection, my lord.
as regards what?
Second objection, my lord, regarding the passport. My lord, will find an authentication on the second page, my lord, duly stamped by the immigration office.
He is saying that it is a photocopy.
My lord, it's a photocopy and it has been duly authorized, my lord.
That
My
it
lord,
has not satisfied the provision of section 109. That's what is contended of the Evidence Act.
my lord.
That is a public document and it is a photocopy and it has not satisfied the provisions of section 109 of the Evidence Act. That's his contention. It's not saying that it is not stamped. He didn't say that. What he's saying that being a public document, an international passport is a public document, and that it is not it has not met the requirements of section 105 of the Evidence Act, laws of the Federation.
As the court pleases, my lord. Look, the document has been certified. Although it's a photocopy, my lord, if my lord peruses the document, especially the last page, my lord will find that there's a certification contained on the last page.
The thing has been certified, is it?
Yes, my lord.
In what page?
The last page of the document. Republic of
Yes.
Yes, my lord. As to the third document that council raised his objection on, my lord, if my lord takes a cursory look at the document, my lord will find that original acceptance letter duly
A
signed.
closer look at the document.
At the document, my lord will find that that's the original acceptance letter.
It is
The original acceptance letter,
it is the original
acceptance of the letter of employment,
acceptance of the letter of employment. Yes.
duly signed by the claimant. My lord will find the claimant's signature in bold blue pen. The fact that the document was it was a photocopy that was given to him is of no moment, my lord. It was a bold blue pen that was used to accept the document. That's the original of that document of his acceptance. It is not a photocopy, my lord. Yes, my lord. The fact that the document itself
Yes.
is a photocopy, as a letter of employment itself is a photocopy, or is in black and white rather, my lord. That's the proper language. It's in black and white. Does not make it a photocopy, my lord. My lord takes a look at it, the document, my lord will find the defendant's signature in bold blue ink on all the pages of the document, my lord, including the acceptance page.
An acceptance of the
My lord will find,
employment of the defendant.
yes, my lord.
Yes.
Including the last page, which contains his endorsement, my lord. It's written in bold blue pen, not a photocopy, my lord. On the basis of this submission, my lord, we urge my lord to dismiss the contentions of the Claimant Council and enter these documents into evidence, my lord.
Defense again. Yeah. Mhm.
But the doctrine which is one subject in our students,
The doctrine
one subject is one of relation back.
in our jurisprudence. Yes, that.
Relation back.
Hmm?
What simply means that pleadings carry of the claimant
That pleadings of a claimant
upon amendment dates back to the commencement of the suit. And so the court cannot look at previous pleadings by the last suit when it has been amended. Mention that the earlier,
so the contention
the following the initial process would go talk about go back to that. The second one, as legal attention, it is the duty of council not to mislead the court. But because the second document does not have any form of certification,
Does not have.
any form of certification.
I thought he was his reply is on points of law. The response is on points of law. Address the law, not facts.
When I quoted the law, which a council is not duty bound to do. And so on the premise of that law, I can
Hold on. You said, as ministers in the temple of justice, there is a duty on council not to mislead the court. The second document does not have any form of certification. Yes.
What all we have is exit and entry stamp. Cameroon. Stamp on it.
Exit.
Exit and entry stamp, which is used in the practice.
Yes.
And we can see even in Cameroon written on the stamp that I love my certification. That is on that document. Well, in respect of the third,
Yes.
council is not meant to be evidence on the basis of the guise of responding to an objection. Well,
On the basis of reply.
the guise
On the basis of all
of responding to an objection. But clearly, what we have here is that it is followed, does not make it less important than it is. Human claims that it was issued an ignorant letter. And so that should be discussed with the division of ministers. Also, on that basis, we talk a lot of objection.
Okay. You ask the court to uphold your objection and
reject the documents and mark them.
let me see them. Did you make reference to section on 109 or 104? 104. Yes. This is my ruling. It is at this stage of tendering in evidence of the following documents by the claimant's counsel, in this case, viz. International passport and Nigeria entry visa, to CV of CW1, that the claimant, 3, letter of employment dated 3rd day of January 2013, and emails of 12th June 2014, email of 7th July 2014, email of 1st July 2014, solicitors letter by firm of Chief Williams dated 17th December 2015, certificate of compliance, though there is no objection as regards to the certificate of compliance and the emails. That the defense counsel raised objection regarding the fact that the amended process of the claimant does not contain the front-loading of these documents as required by Order 2, Rules 10 and 11 of the Rules of this Honorable Court. 2, that the international passport is a photocopy, and since it is a public document, it did not meet the requirements of Section 104 of the Evidence Act. 3, these documents sought to be tendered are photocopies, and no foundation generally was laid for the tendering of them. The claimant's counsel, however, contended in reply that all the documents are front-loaded with the initial originating process dated 27th January 2016 and filed on the same day, which were duly served on the defendant. That the essence of front-loading is for the defendant to remain aware of the case, that the claimant's case has not changed from the originating process as at filing. The documents remain the same. Secondly, on the second objection, counsel maintained that the international passport has been certified at the last page. Thirdly, that the third document, i.e. the letter of employment, is not photocopy but original, with the signature of the claimant with blue ink. While in reply, the defense counsel submitted that it is settled law that pleadings of a party upon amendment dates back to the commencement of the suit, and the court cannot look at the previous pleadings in the suit. Having carefully listened to the submissions of counsel on both sides and looked through the documents in contention, let me begin by stating that it is apparent that this case was initially filed on the 27th January 2016 and same served on the defendant along with other processes, including the front-loaded documents. However, an amendment of the process was sought for and obtained, which brought in the filing of the amended process on the 15th of January 2024. The position brought by the amendment in law, therefore, is not two-way, as the law is settled as rightly submitted by the defense counsel, that the amendment dates back to the commencement of the suit, and so the court cannot look at the previous process since same has been amended. The court can only look at and concentrate on the amended process in considering the case. In this situation, I agree to that extent with the learned counsel for the defendant that the legal and the legitimate process is the amended one upon which the case of the claimant is built and premised. In this case, the process and pleadings filed on the 15th day of January 2024, but not the one that was filed on the 27th of January 2016. Now, there arose a contention that the amended processes do not carry along itself that the amended process does not carry does not carry along itself the front loading of the documents sought to be tendered in evidence, as required by Order 2, Rules 10 and 11 of the Rules of this Honorable Court, 2017. Let me say that although issue of front loading of a document with a process is required under our law, but Order 2, Rule 10 and 11 cited by the Defense Council does not make Order 2, Rule 10 and 11 cited by the Defense Council in any way do not make any provision of front loading mandatory. Though it is required, I believe that, as in this case, having not complied with the provisions of Order 5 of the rules of this Honorable Court in its general form cures the defect, since the claimant has provided the amended list of documents upon which he is to rely on at the hearing of the case. It is, of course, the law that upon realizing the non-front loading, the Defense Council would have taken steps to set the process filed aside for irregularity, but failed to do so until at the stage of trial, where he raised the issue orally. To my mind, allowing this would amount to promoting technicality to which this court should be unduly tied down by such technicality, particularly where no miscarriage of justice is occasioned, as the Defense Counsel did not state that in his argument to persuade me. It is therefore in this regard that I overruled the objection raised by the counsel for the defendant, seeking for this court to reject the documents sought to be tendered on the ground that they are not front-loaded. They are not front-loaded to the amended originating process. This is more that the documents are conspicuously listed and same forms part of the amended process. Regarding the fact that the international passport is a photocopy and has not complied with Section 104 of the Evidence Act, the basis of which that it is a public document which was not certified, and also that other documents sought to be tendered are photocopies which were tendered without laying foundation as to the whereabouts of the originals. It is my view that provisions that deal with tendering of documents in evidence at trial before in this court is at trial. In any trial is the Evidence Act. The law regarding the tendering in evidence of a document are categorized into three broad factors. These are: one, whether the document is pleaded; two, whether the document is relevant; and three, whether it is admissible. Looking at the pleadings of the claimant, particularly the amended statement of facts, I find that these documents are pleaded. By such pleaded facts, the documents are relevant. However, can I say or hold that though pleaded and relevant, are these documents admissible in the trial of this case? This court, by its very nature, is ranked as a specialized court established under the National Industrial Court Act 2006 and re-echoed by the Third Alteration Act to the 1999 Constitution of the Federal Republic of Nigeria. It is very clear that by the provisions of Section 12, subsection 2B of the National Industrial Code Act 2006, it is therefore it is provided that in any proceedings pending before the court The court may, as a specialized court, A, regulate its own procedure and proceedings as it thinks fit in the interest of justice and fair play. B, in appropriate circumstances, depart from the Evidence Act in the interest of justice, fairness, equity, and fair play. It is therefore my considered view that in any proceeding such as the one in issue before me, this court can apply fairness and indeed flexible procedure and shall not allow mere technicality to becloud doing justice to the parties based on law, equity, and fairness, while considering the entire facts of the matter before it. The provisions of Order 5, Rule 6, 2B, and Rule 3, whereby this court, as a specialized court, can regulate its procedure and proceedings as it thinks fit, and in appropriate circumstances depart from the provisions of the Evidence Act. Therefore, in the overall interest of justice, equity, and fair play, coupled with the specialized nature of this court, I overrule the grounds of the objections raised by the Defense Counsel and hereby admit the documents in evidence and same be marked as Exhibit C1 to C6. Having been listed on the amended list of documents, and for the clearance of doubt, they are International Passport Exhibit C1, CV of the claimant Exhibit C2, Letter of Employment Exhibit C3, emails of 12 June 2014, emails of 7 July 2014, and email of 1st July 2014. The three are cumulatively marked as Exhibit C4, and later from the solicitor to the claimant Exhibit C5, and finally Certificate of Compliance Exhibit C6. That is the ruling of this court. Yes, okay. Yes.
Witness, are you still with us? Mr. Lucian.
Yes, I'm here.
Okay. So, Mr. Lucian, in the whole, what would you like this honorable court to do for you in this matter?
I respectfully ask this honorable court to grant judgment in my favor and order payment of my outstanding benefits which I earned and I was entitled to.
Well, that's the case of the as our examination in chief for the CW1.
Any cross-examination?
You
have cross-examination? Go ahead. And mind you, we have pasted something on the witness box over there. You can see the time, because of some other cases that we have to be conscious of the time. You have a very good 20 minutes to do the cross-examination. The witness is here with us. When you exhaust your 20 minutes, we will look at the possibility of perhaps giving you additional few more minutes so that you can conclude. This is a 2016 case. That's why I have to sit down and deliver this bench ruling. Because the nature of the objection raised, in fact, I would have risen to go and start writing a ruling and coming back. All this is, there is no point delaying this matter. Yes. A 2016 matter before me, I don't have any excuse to say, how can this matter be going? Because this matter was filed 2016, and it continued going through one court to the other. Before my learned brother, from this court to the next, and finally it came to my court.
But just to add, what my brother just said, it has been an instance.
Very well, let's continue. You are taking more of your time. Question one?
Yes, but
Yes.
Mr. Lucia, that is the counsel for the defendant. He's going to ask you some questions
Okay,
from
I'm
what you
here.
have deposited on your evidence before this court. You
Yes.
listen to him.
I listen. The only problem, his microphone, it's in the back, and I cannot hear properly. You know, but
Okay, we will make arrangement that you can hear him. Counsel,
is
be audible to him.
Can you hear me?
now a little bit better. Can you keep the microphone more close to you, please?
Can you hear me?
Yes. Okay.
Please, can I have the exhibit? Now, in
The counsel, the exhibit. Give him. $25 past 2. Counsel, see the whole clock there. It is 25 minutes past 2.
yes. Now, if I in your witness statement on oath, you refer to ancestral exhibit C5, which has 10 million as fees to your counsel. Is that correct?
The voice is making echoes, your voice. Can you use the microphone of my lawyer, please? Or keep the microphone close, because you speak from far and it's making echoes. You understand?
Can you hear me now?
I can hear, but you understand your voice is making echoes. It's like it's not clear. It's not clear. Very
more closer so that you make use of the
very clear. I can hear. Yes.
You can make it, bring your phone much more closer to your mouth so that you can speak to the speaker.
Yes.
Can you hear me now?
Okay, now it's better. Tell me.
Okay. So I said you had tendered exhibit C5, a letter to you from your lawyer as
Yes.
basis of your claim for 10 million. Is that correct?
Yes, this is the
So, as of 2016, when you filed this matter, or December 2015, when this letter was issued,
as at 2016,
December 2015 to January 2016.
So December 2015 to January 2016. Yes.
The exchange rate between the naira and the dollar is not more than 200 naira to $1.
If you
not more than 200.
200 naira to $1.
Yes.
Is that correct?
I was my benefits, it was in US dollar. So the time we make this correspondence with the defendant, we make based on the claims and which was already approved. My per diem, it was approved by my line manager. and the
I-
defendant
you need to understand my question so that we'll save
part,
time. We don't have much time.
defendant,
Lucian,
yes,
please, you need to understand my question so that we don't waste much time. What I asked you was that after when you claim that your lawyer said it will cost, it will charge you 10 million
yes,
to do the matter for you, that the naira dollar was 200 naira to $1.
into this means in 2023, correct?
In 2016, when you filed this matter.
Okay, let me check. In 2023, you mean the
2016. January
2016?
2016.
Okay.
If you don't know, just say you don't. Let's move on.
Yes, in January 2016, $1 was approximately 200 naira.
Okay. So I'll be correct to say $14,900 by 200 naira is less than 3 million naira.
It's true
Sorry.
that you will be right to say that
At 200 naira, your claim, which is 14,900, approximately $14,900, less
Yes.
than 3 million naira after that date.
$9,900.
$14,900.
$15,900.
I am sorry to
So
say,
your
but
claim is roughly what? Because I have to record you. I'm
3
writing.
million naira.
What's your answer?
yes, so my claim, it was done, the outstanding benefits is in dollars, correct? And what is
Sorry,
writing?
please, can you
Yes.
please just answer the question so that we'll save time. We will not have much time to do
Okay,
this exercise.
so this 14,492 US dollar at the course of 2016 January, it's about 2,900,000 naira in 2016.
Okay.
Yes.
So you want this court to believe that you agreed to pay 10 million naira to recover less than 3 million naira.
Can you repeat, please? I don't understand.
I say you want this court to believe
Yes.
that you agreed to pay 10 million naira to recover less than 3 million naira.
What do you say to that? What's your answer?
My answer is that the court to order to pay me all the outstanding benefits, and also because I was waiting for all these 10 years for this matter to be solved, I ask to settle this matter in my favor. Simple like that. I ask to have for the general damages to breach my employment contract. And
My lord, you haven't answered the question.
He's your witness at this point now.
You've not answered the question. I'm not asking you what you are. I said you want this court to believe that you were willing to pay 10 million naira to recover less than 3 million naira.
but these two are two different amounts of money. You understand? You asked me something about naira. My claim, it was in dollars, okay? And the defendant paid part of my outstanding benefits, but they refused to pay the rest of the money without a reason.
We will get there. We will get there. What I'm asking you is simple. So since you don't want to answer, let's make progress. Now, do you have evidence of any payment you made to your lawyers before this honorable court?
Yes, all the evidence, it was submitted. I have all the payslips and all the forms which was approved by my manager, and also the correspondence with the defendant regarding
That is not my question to you, Mr. Lucian. That is not my question to you, Mr. Lucian. My question is, do you have evidence of any payment you made to your lawyer in telling you the claim that they wrote to you?
If I have any evidence of payment,
To your lawyers.
yes, I provide to my lawyers all the payments, all the pay slips.
But I think we have difficulty here.
Witness.
Yes.
Okay. The counsel is asking you.
Yes.
Whether you have any document.
Yes.
Before this court showing that yes, you made to your lawyers such a payment. Is there any document in your hand or that you are presented to the court?
Yes.
Showing that you have made payment to your lawyers or evidencing the payment of such monies to your lawyer?
If I pay money to the lawyer?
Yes. Is there any document to show that really you paid money to your lawyer?
To my lawyer, yes. Yes, my lawyer, yes, I pay by bank transfer, yes.
Is it before this court? Did you tender evidence before this court?
Counsel, you should know the number of documents that are tendered. If it is there, you know. Let's proceed to the. There is no need when you know actually that the document is here.
As a copy. No,
yes, I paid my lawyer, but and my lawyer.
We are past that stage. Let's make progress.
Yeah.
I don't have much
yes.
time.
Yes.
Now, in your statement on oath, you claim that as paragraph 19, you claim that the defendant was owing you $32,547.98. Is that correct?
Again, is your voice? It's you speak. You don't speak next to the microphone. I don't understand you with echoes.
I said in paragraph 19.
Okay,
Paragraph
19.
19 of your deposition.
Okay, paragraph 19. Okay.
That you had unpaid financial benefits of $32,547.98.
Yes.
Do you agree with it?
Yes, I agree with this paragraph 19.
Okay. So as the email you sent, you said you sent on the 12th of June. There was no such amount of $32,547 owed to you. As at that date, you claim you sent a mail.
What's your answer?
In the email which I sent to the company, I told them that I received this 6,000, which was part of the per diem, and remain other part of the per diem to receive from the company. But the company didn't pay me the rest of the money. They acknowledge my claim, but I was not. They didn't continue to pay me the rest of the money. And
You understand my question? My question is that as at that date, there was no 32,547
yes,
to you as at that date.
yes.
Okay.
From this
6,000, the 6,000 you claim you received was paid to you in October 2013.
October what? October 13?
October 2013.
Yes, so in October, I also receive another 5,000. You see, in paragraph 23.
Hold on now, wait. Just hold on. Just follow my question. Don't just stick to the question I asked you. Okay? So that we'll make progress. We don't have much time. What I said is that 6,000
Council,
you refer to.
your face is not visible here on the screen. You are not appearing on the screen. The way she's holding the. Yes, you better hold it very well for him, and so that the council can.
That's the challenge we have.
And you're appearing with two persons there.
In the place.
Council should also come in to help. Your voice could be heard, but your face is not seen.
Can you hear me now?
Yes, okay.
So my question to you was that, or is that, the 6,000 you referred to in paragraph 19 was paid to you in October 2013.
He has answered that. He said yes.
This $6,000.
Yes. Now you said it's correct. Now your letter.
Yeah.
The letter you said your counsel or your lawyers wrote to the defendant on 17th October 2014.
In October, I
in paragraph
received
22. Hold on, we move past that one now. Paragraph 22 of your witness statement on oath. Have you seen it?
So first I received 6,000, and after that this
Hold on.
7,000.
Understand my question. We don't have time for this. We don't have the whole day for this process. I referred it to paragraph 22. Now, in that paragraph, you claim
Yes.
that your lawyers wrote to the defendant,
Yes.
and it was subsequent to that letter that you received 5,055.
Correct.
It is statement on oath. Statement on oath.
Look at the statement of rules that was. You have a copy. The one that is.
What is that I'm using?
The one that is notified.
But it's part of the process.
But what I'm talking about is the one that was right.
With due respect, my lord, to my colleague on the other side, they have the document they front loaded, and our understanding is that it is from this one that they made the notarized
Okay, to be on the safer side, just make reference to the one that the witness adopted before the court and which is taken as the evidence. Can you read that paragraph?
Paragraph 22.
22.
Yes, my lord.
Read it out.
Even in the one that he's referring to. Read. That in line with the claimant's instructions, if solicitors wrote to the defendant demanding payment of outstanding financial benefits. So I wonder if they say that I'm reading from something else. It's the same thing. The same thing has in the one that should have been before the honorable court, and the one that was authorized. The same sentence, the same paragraph, and the same document. So they didn't tender. Well, my time is going.
He received $5,000.
No, $5,055.
Yes, this money it was.
We're taking paragraph 22 and 23.
Yes, and that's
23. May I suggest to you that the $5,055 was paid to you before that lawyer's letter to the defendant?
Yes, this was a standing salary, because I can tell you from the experience to the defendant.
No, just get my question, please.
Yeah.
Please, sir, don't waste time on this. My question is that $5,055 was paid to you before your lawyer wrote.
This 5,000, it was paid to me before we go to the court. Initially, I tried to do internally inside the company to claim all this money. I didn't find understanding, and after that I contact a lawyer, and the lawyer tried to do it amicably, to do it friendly. They sent a letter to the defendant to ask for my benefits.
What I'm asking you, Mr. Lucien, is that money was paid before the lawyer wrote that letter.
This money, it was paid.
$5,055.
Yes.
He hasn't answered. He hasn't answered.
The other money, 14,000, there was
my question.
Upon that letter, they paid from
That is not my question to him. My question to him is that the money was paid because the lawyer wrote. He hasn't answered. My lord, may the records get me out. He hasn't answered this question.
He said, yes, this was an outstanding salary. It was paid before I filed my suit. That's what he said.
My question to him was, it was paid before the lawyer wrote. It was paid before your lawyer wrote. Is that correct?
Witness, did you hear that question? Did you hear the counsel asking you that question? Witness.
Wait a second, because I need to check the payment slips, okay? Okay, the payment of my salary for July 2014, it was made in October 2014 with big delays.
What date was it paid?
October 2014, okay, I will check because I need to check the payslip to see when this money, 5,000, arrived in my bank. Okay, let me check.
Okay, may I help you? Can you look at that letter? If you can see it, I don't know how you can show a copy of it. Your letter, your lawyer's letter, which you refuse to tender. Well, they had it in their first document. Part of their document.
Is it an evidence before the court?
Well, they listed it. They listed it.
The question I'm asking you, is it admitted in evidence in this matter before the court?
Well, they didn't tender it, so it hasn't admitted. Well, I can tell that documentary.
You can do that, but did you lay the foundation to that extent? These are areas where you would have taken. You have to show, you have to lead the witness to identify that document really and understand that, yes.
Because that's what I want to do.
But you are mentioning the letter, you are going ahead mentioning the letter. And asking him about a letter which is not even in evidence before the court. You didn't do it that way. You're asking a question about or from a letter that's not even an evidence. I didn't even notice this.
That's why I didn't refer to the letter as an exhibit. I would have said, look at the exhibit.
Anyway, go ahead. But
to be shown to him. So the lawyer wrote a letter dated 17th of October 2014 to the defendant.
I will tell you this $5,055. It entered inside my bank on 3rd October 2014, and I have the payslip from the bank. 3rd October 2014. I can write here. Wait a second.
Please, I want to look at the letter of your lawyer.
I have. Wait a second.
I'm aware that he has said to. I saw the document. I told him you need to confirm.
I had to show the witness.
So please, there's a letter from your lawyers dated 17th October, which is this number 9.
You say
in your list of documents, and also in paragraph 22 of your deposition.
There is a letter listed as
As number 9.
That's document number 9 on the list of your documents. Emanating from who?
Emanating from your lawyers to the defendant.
And which is the date?
17th October 2014.
17 October. So it's after I received this $5,000. $5,000 I received on 3rd October.
Okay.
I have the evidence. I have the payslip, and the payslip, it was sent to my lawyer. All this bank transaction I sent to him. He can show to you anytime.
Okay, I just want to show you the letter. If you can identify it. I don't know how best to go about it. Your camera be clearer to show him. This one is the camera.
You need to bring a little bit closer to me because it's too far. Okay, yes. Okay.
Is that your letter?
Yes, it's letter which I instruct the lawyers to send in my name to the defendant.
And the original is which now?
Huh?
The original is where? Who has the original?
The original?
Yes.
You ask the lawyer where is the original.
Well, I mean, I wish it, would I be correct to suggest to you that the defendant has original since your lawyers wrote to them?
Yes, the lawyers, they write this letter in my name as per my instruction.
Well, I think internally documents.
Do I suggest to you that the lawyers, which of the lawyers for the defendants?
Your lawyers wrote to the defendant, and the original is with the defendant.
What did he say?
He said yes. Yes.
Yes.
Not apply to tender.
Let me.
No objection?
I just sent now the evidence of the payment on 3rd October.
The letter from the law firm of the council for the claimant dated the 17th of October 2014, listed as number 9 on the list of documents tendered in evidence by the defense counsel, which is not objected to by the claimant's counsel, is hereby admitted in evidence and marked as exhibit CX7.
As the court places. So, Mr. Lucian, I'll be correct to say that you lied to this court.
What?
I shall be correct to say that you lied to this honorable court when you claim
Yes.
in your paragraph 23 that
Yeah.
that payment was made to you after you wrote to the defendant.
Yes, correct. 23. So the letter it was sent by the lawyer was sent to the defendant for this amount of money. After I receive.
He said, so I will be correct to say that you lied to this court when you claim in paragraph 23 of your witness statement on oath that counsel,
that the payment was made after his lawyers wrote to the defendant.
But in my statement of witness, here is writing clear on paragraph 23.
So what is this? What are you saying?
So what are you saying?
What's your answer to that question? He's putting it to you that you have lied.
I didn't lie. I write clearly here what was remaining from my outstanding benefits, remaining the amount of 14,000 after they paid this 5,000, because this 5,000 it's cut from that outstanding of paragraph 20, which is 19,547. So 19,547 minus 5,055, which I received on 3rd October, remain this amount of money, 14,492. And my claim is for this money, is for what remain. I didn't ask again for 5,000.
That is not my question to you. My question to you is very straightforward. That your paragraph 23 is a lie. Having received this money before your lawyer wrote.
How I received my money before the lawyer?
Let's not waste for that time away. Now, the per diem you made reference to. I hope you can hear me. Mr. Lucian, can you hear me?
Yes, I can hear you.
Now, the per diem you made reference to is designed to take care of accommodation and feeding if you're outside the country.
If I'm outside the
council? Come again, counsel.
I said the per diem.
Yes.
Is it $300?
Yes.
Is to take care of your feeding and accommodation.
This money,
if you're outside Nigeria.
Yeah, this money it's stated in my employment contract.
Or no?
Oh, per diem is
yes or no? If
per
you're traveling
diem,
outside the country,
per diem
is to take care of your accommodation and feeding.
Accommodation, feeding, and daily expenses, plus to compensate the hardship of the work environment.
Okay.
Understand?
Okay. Now, the defendant, when you make the request, wrote to you, telling you or before then? Whereas while you were in Douala, Cameroon, you were accommodated and fed on the badge of the defendant.
While in Douala, Cameroon, you
were accommodated and fed on the badge of the defendant.
Who accommodate me?
The defendant, Ekulu Cheyenne.
Let me
You
tell
were
you.
accommodated there. Please hold
Yeah.
on. Let me ask you. Let me ask my question. You were accommodated there and fed there.
This is not correct.
Is it not correct?
Yes, I will tell you why. Because
Okay.
as per my status and my employment contract,
Hold on now. Hold on. I'm not asking you what you're entitled to. I'm
Yes.
asking you what actually happened.
yes,
So what I'm saying is it is correct that you were accommodated there and fed there while you were at Douala, Cameroon.
it's not entirely correct what you are saying, because it was against my desire. I was asked by the company to look closely to the work, and I did a very good job. You understand?
Okay. So
the company promised they would pay me the per diem.
No, hold on.
As it was the order. You understand?
Let's take one after the other. What I'm asking you is not what ought to have happened. What I'm asking you is simple. While you were at Douala, Cameroon, you were accommodated and fed by the defendant on the badge.
No, it's not correct.
Okay.
Because I don't stay all the time on the barge. I also going to eat outside. You understand? There was not all the time food available.
Okay.
Because the kitchen, it
was
in dry dock. You understand?
Yes, I want to refer you to your email of July 7th. Your email of July 7th.
Where I must look?
Your email.
Yes.
That you sent.
7.
July 7th.
Yes.
2014.
Yes.
Now that email was a response to your supervisor feedback.
Yes.
That you were accommodated and fed on the badge all through your stay there.
I said he ordered me to stay on the barge. Okay.
Just answer the question. Don't tell me what happened.
I will tell you. So let me answer. He ordered me to stay there. I stay on the barge.
That's not my question. Get my question. Your email was a response to a mail of 2nd July being feedback from your supervisor stating that you are accommodated and fed on the badge all through your stay.
My email response, it was response to the email of Miss Chini Ifeani, which she sent me on 2nd July.
Okay. So that email.
And there, yes.
That email from Chini forwarded to you.
Yes.
Your supervisor's assertion.
Okay.
That you were accommodated and fed on the badge throughout your stay. That's correct.
I stay on the barge because he asked me to do
No, I don't
that.
see. Don't
It's
go
not
on,
was
stay.
not
So
my
let's
choice.
maintain this story.
Was not my choice. You
Please
understand?
move on. I'm not asking you about your choice.
Yes,
I'm not
it
asking
was
about
not
it.
my
That's not my business
choice.
now.
Yes.
What I'm asking you is simple. It's in response to that feedback.
Yes, so I stayed together with my other colleagues.
Okay.
And
okay,
they were
okay.
paid. And they were paid. You understand? And
Please,
me, I was not paid all the benefits. Simple
please.
like that.
Can we just stick to this so that we don't waste time? So we'll spend how many minutes on this thing? Let's just make progress. It's a very simple question. Don't go round and round. It was a response to a mail, yes or no? It's a response to a mail saying that you lived and was accommodated and fed on the badge. That's a simple question. So it's a yes or no answer.
I stay, but I didn't stay all the time. You need to understand that.
Please, do you have any documents? Where is that? Now, that's your email. Huh? Your email of 7th July. You did not deny that assertion that you lived and were accommodated on the badge all through your stay.
I didn't say I stay all the stay. You understand? Plus,
I'm referring to your email now.
Plus, also,
the
line manager stayed there on the barge.
Oh, hold on, please. Do you have the email before you? So I'll go through it. So I don't waste time on this. Do you have the email, your email before you?
Email?
The email of 7th July 2014. Do you have it before you?
Okay, yes, I have.
Okay. Now, is there any statement in it where you denied or suggested that you ever lived or ate outside the badge all through the period?
You can read. You read what I write there.
There's no.
I didn't deny I didn't stay. I told you I didn't stay there all the time.
Okay.
You understand?
That's established, right?
Yes.
That's established, isn't it?
Because
so let's make progress on that point.
Yes.
Let's take it bit by bit on that point. Now, your claim is that he promised you to help get out the attempt, even if you lived and stayed on the badge. If you did a good job.
Counsel, I will have to draw your attention. You have exhausted more than 40 minutes while cross-examining this witness. Ahead, we have some other matters to attend to. And the rules of this oral code is very, very clear. That's why I drew your attention. I say you are starting your cross-examination at 25 minutes past. So,
the challenge we have is the witness.
Every case has its own challenge, but then the issue is how do you manage your case? How do you manage your case? Because every case you see, even if it's a case of arrested a flight, it has its own peculiarities and problems. So how do you manage your case? And this court is bound to manage this case as well and to manage the court. There are some other cases awaiting, and the rules of this court has provided highest, at most, we can give you 40 minutes for you to do the cross-examination. And you have exhausted more than that. In view of that, that's why it has been stated, we have pasted it there, 20 minutes. What is there? All your cross-examinations, I can see, that are based on those things that are stated in the witness statement on oath. And this is already before the court.
No, this is the meat of the justice of this case.
In any case, the pattern of your cross-examination is the one that is leading to up to this stage. Yeah, this is already before the court. You have been served all these things. You are still reading it to the witness to either to approve or to disapprove. That's
No, my lord, with my lord may hear me out.
I will give you additional 5 more minutes, please, to conclude. So that we can attend to some other cases. It's already past 3 now. It's after 3. And we've been sitting here since morning.
As a couple, is my
I
lord,
have written more than 48 pages now. More than 48 pages. And we cannot just take the whole day for this particular case when the rule is so conscious of this kind of time.
My lord,
I said I have given you 5 more minutes. This is now 10 minutes past 3. If it is 3:15, I will ask you to stop.
As a couple, my lord, it's actually.
I'll give you a bonus of 2 more minutes.
3 minutes, my lord. Now,
regarding your question, let me answer.
I have a short time to do this, please.
Yes.
I'm in possession of the court at this point.
I stay on the barge. Yes, let me.
Can you keep quiet and hear me?
Yes, I stay on the barge. However, other colleagues. Yes. However, other colleagues.
Witness, both of you are timed now. You have less than 5 minutes now. So listen to the counsel as he asks you a question, and then you give him answer.
Okay.
You have that duty to answer him when he asks you a question. And if the question is not well, we will ask him to repeat.
Okay, so my question: the defendant has the right to confirm whether an employee is entitled to any claim or not, in respect of per diem or any whatever he claims the company should pay to him.
At no time was I informed that.
Please answer the question. Is that correct?
Let me answer you. Don't stop. Let me answer. Don't stop. At no time was I informed that the per diem was incentive rather than an entitlement.
At no time.
At no time.
Again. Yes.
At no time was I informed that the per diem was an incentive rather than an entitlement.
Yes.
The promise you claimed that the supervisor made to you, that he will help you get it out, even though you didn't spend any money on it, was because ordinarily the design of per diem was being taken care of by the company.
I myself received part of my per diem during this period. Other colleagues who also stay on the barge were still paid their per diem. Clear.
Do you have any documents? Do you have any documents?
I spoke with them. It was my colleagues. I work with them.
Do you have any documents or evidence before the Honorable Court confirming that they were paid? Even if they are accommodated on the badge.
Even if they are accommodated on the badge.
I didn't come in this court to discuss the per diem of other colleagues. I came to discuss about my case. My case. Fine. You understand?
That's fine. Now, I'll put it to you that it will be fraudulent, or it is fraudulent of you, or even your supervisor, to want to help you get out from that you're not entitled to.
You should also know that whatever you are saying, I'm recording. And the rate at which you are going, I find it very difficult to record you.
I'm so sorry. Well, yeah, it's like I'm under pressure to make sure that we do whatever.
And you want to put the court as well under pressure?
I'm so sorry
The
about
court
that.
cannot be put under pressure in any way.
I'm sorry about.
Yes.
So sorry about that.
My
I just to
duty.
stay the time for the honorable court. I thought I'm so sorry.
Yes. You are
Well,
reminded.
my question was that.
Is that the last question?
That's the last question.
That should be. That should
So
be.
this is the meat of this whole thing.
Because we cannot afford and reprogress.
Well,
I've
this
given
is
you
actually
my
the
order.
crux of this matter. The
Yes.
crux of this matter is based on this question. So because
Finally.
you're paid to do a good, you're employed to do a good job. It will be fraudulent of you and any supervisor to promise to get a per diem.
It will be what? It will be what?
Per diem. It will be fraudulent.
Because you are employed to do a
Unlawful.
job, it will amount to fraud, eh?
Fraud or illegality or lawfulness.
Yes.
For you or a supervisor to collude to get out a per diem.
Let me go.
The company has already provided the purpose for.
Let's go to the contract,
Answer
employment
the question.
contract.
We don't have time. Just answer the question. It's simple. Don't go round and round.
Did you understand the question?
I don't, because he's making so many words around.
That is
I don't
it.
understand. It's very, very unclear for me, you know?
Read it again. Read the question
My
again.
question to you is, okay, the foundation is that you claim that they promise to help you get it out if you do a good job. Or your supervisor. I'm now suggesting to you that because you are employed to do a good job and not a bad job, you and your supervisor colluding or agreeing to help get out a per diem for which the company has already provided accommodation and feeding for you would be to rip off the company.
This per diem is paid for all the people which is traveling outside the country. Nigeria is also writing inside my employment contract. Look at the travel. Look inside the contract. The travel policy is writing clearly where the employee is required to travel temporarily outside his normal place of work on company business. The company will provide the necessary travel expenses, tickets, accommodation, and commensurate out-of-pocket allowance. So this is outside, it's additional to the salary. Do you understand? Doesn't matter.
You understand? And that should be.
I never suggested that per diem is part of the salary. The point I'm making to you is simple.
No, per diem is not part. Per diem is extra the salary, my friend. Look inside my employment contract and read.
He said it's part of his claim.
Not whenever in doubt as to what per diem is. What that he was there as against his will. That is his claim. It doesn't change whether we understand what per diem is.
Then what do you do with this kind of thing as a council?
I'm sorry, Mama.
What do you do with this kind of thing? It's not in all respect or in everything that you have to extract. When a fly passes in front of your nose, you must not smell it. So I think you have exhausted your time. And for that, I will ask you to stop at this stage. Any cross-examination? Any re-examination, sorry. So, where are we now? Speak out. Let me hear you. You're saying there is no defense? Okay. Are you bringing in more witnesses, or that's all for you? That's all for the claimant. And you want your Pastor Lucian,
Yes.
you can step down. You can leave the meeting if you so wish. Claimant's case is closed.
Lord, with due respect, my friend, there's a difference between honorable court. Well, with due respect, my friend, there's a difference between honorable court. Well, we filed the defense.
We filed a defense.
Yes, my lord.
In this matter before this court.
Yes, my lord.
Yes.
My lord, even filing a consequential amendment is something of choice to the defendant, where there is an amendment by the claimant. What the amendment was just their name, the claimant's name, and that's all. Nothing
These are all
substantial.
matters of address.
The body.
Yes.
And so, my lord, we are asking for a date for defense.
Agree on a date in January. I didn't like this case to cross over to January 2026, but the situation, the circumstance, and particularly the time we took in the cross-examination, we have no option. We have to take it as far as to January or whatever. We have adjourned cases to March, but I don't want this one to go to March. Look at either January, February, and find a date for them. 2016 matter. And in a labor court, it's unbecoming. In fact, everybody will throw his face at that. A labor court, a case maintaining about 9 years. And you can see even after then, the exchange rate was 200 naira a dollar. Now it's 1,500 or more. You see, the problem with this kind of thing, that if there are, what date? 19th of January. Is that convenient?
It took our application from the short
based on the agreement of counsel on both sides. This case is hereby adjourned to the 19th day of January 2026 for defense.
over NICN/LA/313/2023 between Mrs. Shobayo Solabolu against the Managing Director, Chief Executive Officer of my company Aviation Service Limited. Mrs. Shobayo, can you hear me?
Yes, I can hear you, please.
No,
you can leave the meeting.
You can leave the meeting. I've already told you. You are not part of it.
Okay.
Yeah, you can leave the meeting.
Okay, bye-bye. Thank you very much.
Bye-bye.
Have a nice day, Honorable Court. Bye-bye. Ciao.
Mrs. Shobayo, are you online?
It's online.
Mrs. Shobayo, can you hear me?
Yes, I can. I can hear you loud and clear.
Okay, my lord, the claimant is present. The defendant is absent.
Appearance.
It is my lord. Adebayo Badmus. Appearing with me are my learned friends, Afiz Soliv and Aziz Siaka. Our appearance for the claimant.
Yes.
Immediately to your lordship. My name is K.T. Olawumi. K.T. and initials. Olawumi. Birthday. W-U-N-I.
Yes, good.
But I'll tell my very friend for the defendant. Felix Ayed. Felix Tola Ajayi. And read one, Jan.
Read one,
my lord, Jan. For the defendant, we're most grateful.
Yeah. Clement.
Thank you, my lord. The matter is for commencement of trial. Subject to my lord's convenience, we are ready to proceed.
Eighty. Yes, well. Yes.
Mrs. Shobayo,
Yes, sir.
you repeat after me. I, your name.
I, Bukola Sholabobi Shobayo,
Swear in the name of Almighty God
swear in the name of the Almighty God
that the evidence
that the evidence
I shall give
I shall give
in this case shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
And on the witness for
Yeah.
Yes.
Thank you, my lord. Mr. Kwayo, can you tell this honorable court your name?
My name is Bukola.
Take us straight to the witness statement on what is the possible.
I'm sorry.
Yeah, take us straight to the witness statement on
Okay, just take a
yeah,
Thank
we
you.
have gotten a name. Is particulars are there stated on. Yes.
Mrs. Shobayo, can you remember the to two witness statements on this matter. One was on the 10th of November 2023, while the second one was on the 5th of November 2024.
Yes. Yes, I can remember.
Now, if you see the witness statements, will you be able to recognize them?
Yes.
Look at the signature page of the first one and confirm to the court if
Yes,
this,
that's my signature appended.
okay, that's the one dated 10th November 2023. While the other one, look at the second one, the second one that you supposed to.
Yes, I acknowledge that's my signature.
Okay. You wish to act up the witness statement as your evidence in this matter?
Yes, please.
Oh, counsel. He said, I remember deposing the two witness statements on oath.
Yes.
One.
Supposed to on the 10th of November. November.
Yes. Yes. And the other one?
Supposed to on the 5th of November.
2024. Very well.
Russia has adopted into evidence.
The two witness statements on oath sworn to by CW1 on 10th November 2023, and the other one on the 5th day of November 2024, having been adopted by CW1, is hereby taken as the evidence in chief of the witness.
Thank you, my lord. Now, witness, you refer to in your witness statements, particularly paragraphs 6, 7, 8, 9, 10, 9, 11, 13, and 15 of your witness statements dated November 2023.
Yes.
You refer to particularly the letter offer of employment letter dated 7th May 2007.
Yes.
Dated
7th May 2007.
Yes.
Confirmation letter dated November 2007.
Yes.
13th
November 2007.
Yes.
Then salary increase and grade change letter dated 21st of January 2015. Then promotion and employment letter dated 2nd of October 2015. Then cessation of appointment letter dated October 2020.
Dated
14th of 2022. Then the code of condition of service by Courtney.
Of
Condition of service.
Condition
Of service of by Courtney
of the defendant.
condition of service Limited.
Yes.
And a statement of account with GT Bank.
Yes.
Now you see copies of these documents. You need to recognize them.
Yes. Yes, I can recognize them.
This is the second.
Okay.
This is the third one.
Yeah.
That's the fourth one.
Yes.
This is the fifth one.
Yes.
This is the sixth one. That's the condition of service.
Yes.
And this is the statement of account, GT Bank.
Yes.
Now, where are the originals of this document?
Ooh, I have misplaced the original documents, and all my attempts to locate them has been unsuccessful.
Thank you. Another thing to take documents for the book.
Getty? Yes. Pass it over to the council for him to see.
And what I intend, because I have just 3 more that you would.
Okay, you want to put them together. Okay, take us through.
Thank you. Now, there's also a letter that you refer to, March 31st, 2023, which was written by
I also have a letter.
Yes, dated March 31st, 2023, which was written by lawyer to Courtney Immigration Services.
Yes.
If you see a copy of the letter, will you be able to recognize him?
Well, definitely.
Okay, take a look at it and tell the court if this is the letter.
Oh, yes, that's the document.
Now, where is the
The original copy should be with the defendant.
Yes. Then also refer to 2 other letters that documents to be tendered. The first one is the 19th of May 2023. Response the counsel to my company, to your firm, to your lawyer. While the second is instruction to take an action by your lawyer, which is dated November 11, 2023. If you see this letter, you'll be able to recognize them.
Definitely, yes.
Can you tell the court if is the
Oh, yes,
response
that is the document.
and the letter of instruction?
Yes, that's the letter of instruction, yes.
I think to have all the document.
Not letter of instruction, the last one. Where is it from?
November 11.
Written to you, the defendant?
No. From the firm of Kunle Adegoke to the claimant. To send out the document. Never. I was looking.
according to what was it? You put it into writing there too. Yes, also you have to write permission.
Yes, well, without our debt, we are the final.
Yes, what the language should be? We have seen the documents, my lord. We have objection, but we reserve.
Yes, I will rephrase that most cases. But I have seen the presented to me, and the documents and Lord, we have objection from the institution of two of the documents presented. I don't know where I did it. Point out the particular document.
Yes, point at them.
But we shall be objecting to the admissibility of the document is on Mark's record. It is the statement of account.
Statement of the claimant's account.
Statement of the claimant's account.
Yes, and which one again?
Just that one.
Okay, so
We're getting to the admissibility of that document. In line with the rules of the lordship, to honor the arguments of the admissibility and the final identity.
No, we went to the bank, we gave him the copies. It's a bank that printed it themselves. It's not what it was needed to have one purpose. Honestly, people addressing. I like that. It's part of the issue. Maybe there's lẹ́yìn àbádá àgùntàn ní kóòtù dìbìtì pa àwọn kóòtù ní ìgbà. Wà á ti ágùn lọ́tọ̀ bá tún ti pa. Only way she got to this prayer and special court, then more than the great evidence to Bangor. Court to the special court, specialized court. Normally, the one by then I see. In fact, there was a time before now. Today, me and I said, if I think that document about the attack, was one about that your position. Mama keep paying. I accomplish. You don't tell it. They go. But you go no right because of the thing that and if you have to be the only time I back to the argument. I can't see you. I can't see you. They can't do it. What does it mean? On that basis, if you see I'm feeling got to know skin, got to know on that basis. What he told me is being me and what we did that could be created here. To get about one who's it. My people, banking. But then simple things. You were different deeply, different than what? Different one bank.
Consequent upon the identification by CW1 of these documents and the application by the claimant's counsel to tender them for admission in evidence, and there being no argument at this stage, objecting to the tendering in evidence of the documents, except that counsel for the defendant has remarked that he will be addressing this honorable court at the stage of his final written address regarding the statement of account of the claimant. I do not have any difficulty in admitting these documents in evidence as applied for by the claimant's counsel. Accordingly, these documents are hereby admitted in evidence and be marked as Exhibit C1 to C10 respectively. Counsel for the defendant shall incorporate reasons for his objection against the document. Again, document he's objecting to its admissibility at the address stage.
As copies. Thank you, my lord. That is all I have for the witness, my lord.
Yes.
What? I'm sorry, my lord. Now, what do you want this court to do for you?
I want this honorable court to grant all my claims.
So we didn't get it. What do you want the court to do?
I want this honorable court to grant all my claims for me.
Thank you.
Very well. Any cross-examination?
Yes.
Yes. Some 9 minutes to 4.
Can you? Can you hear me?
Bio,
Yes, sir.
can you hear the council?
No, I can't.
Okay.
Okay, can you hear me clearly now?
Oh, yes.
Okay, thank you. Sorry, Council, why don't you mute yourself so that you mute your speaker and your mic. Okay. Because time is gone, I would quickly get into it. In the course of your relationship, your employment relationship with the defendant in this instance is by Courtney Aviation Services Limited. Can you quickly remind this spot and myself how many years you spent in the employment of Courtney?
Approximately 15 years.
How many years you said? How many years you said?
15 years.
15.
Yes.
15. In the course of that 15 years, or those 15 years, you have testified that you served the company with loyalty, diligence, and dedication. Are you standing by those testimonies of yours?
Yes.
So it is the evidence that you served with loyalty, diligence in the course of your employment.
Yes.
In the course of your employment, was there any administrative disciplinary process and sanctions given against you?
None that I'm aware of.
Thank you. Were you at any time issued queries, warnings, and suspension?
Queries, yes. A query is a question. You respond to it, yes. I believe everybody in an organization would have received queries once in a while. Yes, query.
Okay, so only queries. Thank you very much.
You're welcome.
Do you agree with me that at some point you are found culpable, sorry, I think I've had. You are found culpable of not complying with regulated authorities and company policy?
I'm not aware of that.
Thank you. Do you also recall that sometime in 2022, the chairman of your company and the board carried out a review of the activities of all the members of management of the defendant?
Chairman and?
Yes, the chairman and the board, sir. Board of the company, sir.
So carried out
a review of the activities of members of management.
What's your reaction to that question?
I'm not a... Is that question for me?
What? Yes, I asked you a question.
Oh, yeah. I'm not
I'll repeat
aware.
myself.
I'm not aware of any review in 2022 by the chairman.
Correct. Thank you. Are you aware of the Is it necessary to ask that? So you agree that on the 21st of September
The question I have written,
2022.
are you aware of? Are you dropping that question?
No, I had asked if she was aware of the management review that was going on. She said she was not aware.
Yes.
So I'm asking a follow-on question.
A little bit close. I have already responded that
Okay, sir.
question.
The second follow-on question is that,
yes.
Are you aware that on the 21st of September 2022, you were directed to proceed on a leave of absence?
September 2022. Yes, I'm aware.
Thank you. It's clear that you've been very helpful. After the review of the management operations that you are not aware of, did you receive a letter of cessation of employment wherein you were asked to leave the employment of the company because of your inefficiency?
Yes, I did receive a letter of cessation of termination that had to do with redundant ways that the company needs to increase productivity, something about competition in organization. Yeah, that was the tone of the letter, but not, I don't think it was redundantly in the letter. Yes.
So the reasons given for your termination are those things that you just read out, right?
Yes.
Thank you.
I think that is what is stated in the letter.
Thank you. Upon receipt of this letter dated 14th October 2022, is it correct that your termination 14th October 2022, my lord? That is the letter titled cessation of employment. What's the exhibit number? It does. It's intended. No. Yes, you. Did you write it? Yes.
The letter of termination?
Yes, no, letter of termination. I just want to quote the evidence number from the file, sir. That's exhibit C5. Most good to sir.
Yes.
Upon receipt of this cessation of employment, that's your termination letter. Why did you reject the terminal pay that was offered to you?
Okay, so the terminal pay that was offered to me was 1 month's salary in view, and that is not my entitlement. That is not my entitlement.
So I want to take it in context. No, hold on. So you are saying that you rejected the 1 month's salary in lieu that was offered to you, right?
Yes.
Okay.
No. I said I rejected because it was not my entitlement.
Yes. Ask for please. Please. Relief source.
Yes.
Most good. I just want to go first. Yes. You have presented a case before this honorable court and demanded payments in the sum of 23 million naira 847,000.
Yes.
Being 23 million 847 507 rather. That's 23 847 507. Based on your own computation of your terminal dues. Is that correct?
No, point of excuse. It's not
Based on
based
your own computation.
It is not based on my own competition. According to the COS in page 9, under terminal benefits, it states that every eligible employer who retires, resigns, or employment is terminated shall be paid terminal benefits in the following manner. 5 years.
Madam, hold on. You just writing.
According to what you said.
Oh, according to the COS, condition of service.
You said it was not based on my computation.
Yes, what I'm trying to say is that it is based on what was written. The calculation is based on what.
Malo, let me guide that properly. Yes. Let me.
I understand what you're saying. I did
No,
the calculation.
hold on. Let me ask the question again. Madam, hold on.
That's fine.
You are reading out to my Lord. My Lord is writing what you are reading. You cannot be reading fast and get it down on record.
That's fine. I will take it one step at a time.
Thank you very much. My question, which you are answering, I don't have a problem with your answer.
They started giving evidence that no, it was not based on my computation, but according to what?
Okay, according to the formula.
I want to hear from her.
According to the
Witness,
formula.
you said it was not based on your own computation.
Yes, the calculation was done based on the formula that was written in the condition of service, page 9, under terminal benefit.
Page 9.
Page 9, under terminal benefit.
Yes.
And I quote.
Thank you very much. Are you done?
No, I'm not done. And I quote, every...
The court has said you don't have to quote. You reference it because of my time.
Okay.
My question, and I'll go back to my question. You have not answered my question. You've gone on your frolic. I hope you satisfied yourself. I said, my Lord, and I want to go record on this. The 23 million naira computation. So, if you can just say, it's made 3 different things. Yes, my other friend, now that you need to answer my own question. I said you have requested from this honorable court the sum of 23 million naira. You have demonstrated, according to you, your justification for 23 million. That's not my question. My question is, how did you arrive at 23 million naira? There's no 23 million naira written on page 9 of the conditions of service, it's just rules.
So you did not allow me to finish. I said that every eligible employer who resigns, retires, or whose employment is terminated shall be paid terminal benefits in the following manner. 5 to 9 years will be paid 2 months of basic salary times the number of years in services. 10 years and above will be paid 3 months of your basic salary per year of service. So my calculation was based on, I am 15 years staff of Bicotany
So
Aviation.
hold on. I will not let you finish. I'm sorry. So this is based on your calculation. That's what that's what I've been asking you. You calculated your terminal benefits based on the provision of Section 9. Is that correct?
Yes.
That's what I asked you. I didn't ask you for the basis.
That is
There
exactly
for
what
anybody to read.
that is what I explained to you. I said
No,
it
you
can
only just set your own question
hold
for
on.
yourself.
I
Anyway,
said
it's
that
fine.
I wanted you to understand that I did not form the figures. The figures
Miss Shobayo, please. Let me tell you how it works here.
The
Hold on.
formula was on the COS.
Please, I ask the question and you will answer me.
Yes.
Yes, sir.
Your duty there is to listen to the council as he asks you question. Then you respond by giving him an answer so that I can record it.
I've given
Don't
him
go into arguments.
Okay, sir.
Yes. Yes, council.
Yes, most grateful, Lord. Most grateful. Yes. So eventually I got the answer. But I'm not sure whether I want to like answer or not. I just wanted to know, and she's answered that it was based on the calculation. That's all I wanted to know. So, witness, the conditions of service, now that you've mentioned it and you've put it in play, even though it's in evidence already, that's Lord, now I want to identify the exhibit, sir. No, it's 6. It's C6, my lord. C6. I just want to ask you a couple of questions on the conditions of service. Do you agree with me that the conditions of service is a document between the management of Bicotany Aviation Services Limited, that's the defendants in this action, and
it's between
the defendants, sir.
The defendant?
Yes.
And who?
And the association. No, my lord. And the Air Transport Services Senior Staff Association of Nigeria. My lord, I will say it again. Air Transport Services Senior Staff Association of Nigeria. Yes, please. Can you? What's your response? My question is: are you aware that the conditions of service you just referred to was an agreement between the defendant, that's Bicotany, and ATSAN, that is the Association of Senior Staff, Air Service Senior Staff Members?
Yes.
Thank you. Are you a member of the association?
No, I'm not.
No, you have to speak up. No, you are not.
No, I'm not a member of ATSAN.
I'm sorry, madam. Did you ever pay check of dues, or was any check of dues deducted from your salary or your emolument as a union member?
Did you ever pay?
Did you ever pay check off dues to the union, or was any such check of due deducted from your account?
Okay, so I never paid any due to the union because I was not a member, and then I'm not aware if anything was deducted from my salary.
Thank you very much. That's like what I'm future is then. and visiting. No, my lord, it's not gone, sir. I started at about 4 o'clock, my lord. So yes, I was looking at the time. I'm almost done, my lord. I just
9 minutes.
Eh?
9 minutes before you started.
Land Council, your day of reckoning is coming.
Started at 9 minutes before.
Yes, you mentioned in your witness statements and you are claiming for a refund of the professional fees you paid your lawyers. Yes, in fact, you are asking for the sum of 10 million naira. Where is the witness statement? Can you show this honorable court the instrument by which you paid your lawyer the sum of 10 million naira as the professional fees, either by check, transfer, or by any other medium?
I never claimed that I paid the whole 10 million. I have only paid 4 million. I don't think you have any document. You don't have any document that says I paid 10 million. 10 million was agreed between me and my lawyer.
Oh, okay. Okay. Thank you very much. So the evidence now that you did not pay 10 million, you only paid 1 million. Thank you. You've been very cooperative this afternoon. Thank you. No more questions for the witness. Lord, I'm very grateful for the indulgence.
I want to clarify. Let her clarify this. You said you did not pay 10 million, but you paid how much?
4 million, sir.
4 million.
Yes.
1 or 4?
4.
4 million. Okay.
F-O-R.
Yes, I've gotten it.
You got it, my lord. I'm sorry, my lord. I thought I had 1 million. Let me just ask one more question on that. Yes. Yeah, I thought I had 1 million. I was going to let it slide, but now that I hear 4, I like money. You said 4.
4 million, sir. Yes.
No, that's giving evidence. That's giving evidence.
Hold on.
You're suggesting to this witness I will not allow. No. My lord, I've been in this game. I know how it goes.
Evidence is clear.
Evidence is clear. She said she did not pay 10 million naira. All she paid was 4 million naira.
I paid 10 million and I paid 4.
Lord, he knows I found her in a lie, and I will not allow him to guess an answer that is against the evidence given already, sir.
I've heard you. What is happening? The witness is here.
I don't
know why they're arguing. The invoice.
This witness is here. And you spoke on oath.
Can I say something? Yes, sir.
Listen, witness, you took oath. You are speaking on oath.
Yes, sir.
What did you say?
I said the agreement I have with my lawyer was 10 million, but all I've paid was 4 million. I don't know how the lawyer misinterpreted it. He likes money, so maybe he heard something else.
No,
don't talk back.
All I said is 4 million.
But if I can speak, sir, it's my good friend, sir. When lawyers suggest responses to witnesses, you hear such disparaging statements from a witness in my box.
But counsel, I think it's
these are some of the fundamentals.
Our life is like. But let me just ask my last question. Let me ask my last question. But I'm not sure I like the condescending tone of this witness to me. You're only guilty here to stick to the court.
A judge sitting in a court is not only limited to recording what the witness or what the proceeding is going about. There are some other things that are reserved for us that we watch. And they always influence us when we come to write our judgment. We remember them.
I'll just ask one more question. I would leave her and her lawyer to coin the evidence whichever way they choose to. The final question.
Finally.
Yes, final, my lord. Final, my lord. I only came back to you because I thought I had 4, but one I got. You said 4. Can you show this honorable court the evidence of the payment of this 4 million?
I have
from the documents. Hold on. From the documents that you have tendered before this honorable court today, can you direct the court to where and how you paid this 4 million?
That particular transaction is not on the current bank statement that you have. But if it's requested by the bank, by the court, I can always request for it.
Thank you. So my question is, you don't have it in court today, right?
No, I don't.
Thank you very much. No more questions, sir.
Very well. Thank you, witness. You can leave the meeting if you so like. Well done. That's the case for the claimant.
Sorry, I didn't get that.
Claimant's case is closed. Yes.
I humbly and with respect, sir, beg the court to adjourn to the 21st of January, which is the other days and before the worship, sir, for defense, sir. Lord, it is the same witness in that earlier matter, that is number 5 of the list, sir.
21st January?
Yes, sir. So 1 January, sir, for defense. It's a very short defense. We can do it and close this case.
Radimus, do you have anything to say? Very well. This case stands adjourned to the 21st day of January 2026 for defense. And it has been a very good proceedings, really. I have seen the maturity in the experience. The displaying the conduct of maturity in both of you.
Thank you.
Yes. So we shall meet by God's grace on the 21st of January, except if there are some other cases that will bring you back.
You'll be seeing us very shortly.
You know, I know counsel who frequent this court most of the time if I see them. Labor law lawyers, you know, they are doing very well to promote, you know, the sanctity of labor in this country. There are some lawyers who do not know, you know, the rules of this court and even names of the parties. Some lawyers will say plenty, some will say whatever. You know, even the rules of the court, many do not know, but those who are very competent, we bring them much more closer to us as friends. If you have any suggestion, please, on how to move this court forward, please, you can do that. You can forward it from the experience you have been gathering, you have seen, you can forward to the headquarters that this is what you see that will promote this court very well. Yeah. Thank you. Very well. I will rise.
Right.